Hi, everyone. My name is Jenni Ives, and I want to thank you all so much for coming today and also for joining us online. I'm an attorney at Stinson, Leonard Street, and my specialty is employment law. I work regularly with human resources professionals as well as recruiters to both counsel them with respect to best practices before a lawsuit starts, and also I litigate matters once a problem arises and assist employers in defending against lawsuits as well. So today I'm going to piggyback off of the prior presenters to talk a little bit about best practices in the recruiting process and how employers can avoid discrimination lawsuits. There's three primary topics that I'm going to cover today. First, I'll talk about how employers can use big data and comply with non-discrimination requirements. I'll also speak a little bit about data that employers may solicit during the recruiting process and pitfalls that employers can run into when soliciting specific data points, including data about a candidate's criminal background and their pay history. I'll also talk briefly about how employers can ensure that their electronic recruiting devices, their online applications, their web apps can be accessible to individuals with disabilities, because that's an area where we're seeing increasing lawsuits. So Jeanette gave us a great overview of big data and how it's being used by employers. So I'll speak about this just briefly, but this is a growing area, and I think that it's something that we're certainly going to, that it is truly the wave of the future, that employers are using data more and more, not only to identify and recruit candidates, but also internally to determine, who is the appropriate person for promotion, what kind of raise should we give them. Data sets are helping employers evaluate the performance of their employees and also really understand employee preferences, their habits and skill sets to better to create a better workplace. There has been data from both Deloitte and the Society for Human Resources Management recently, studies that were done by both of those organizations really showing that employers are increasingly using both external market data sets as well as internal data sets based on data that they've acquired from their own employees to do these different tasks here. And as Jeanette covered, with respect to recruiting specifically, employers are really relying on data sets to reduce recruiting costs, to shorten the amount of time that it takes to recruit candidates and to identify appropriate candidates for a position. And it's also seen as an opportunity to reduce separation costs by recruiting the appropriate and the best candidate for the position, which will hopefully allow a company to retain critical talent. As with any recruiting device or any employment practice, there's certainly risks and rewards to using big data. And Jeanette talked a lot about the rewards. As a lawyer here, I'll talk a little bit about the risks, which is my job. Certainly, there's the possibility that using big data or using a specific algorithm could create or perpetuate discrimination and bias. We talked about that a little bit following Jeanette's presentation. But there's the possibility that an employer could say, I have these top performers, here are their attributes, go find specific potential applicants that meet these attributes. And while the attributes themselves may not be, this person is white or this person is a male, or they may not be specific demographic characteristics, they could correlate strongly to those type of characteristics, and unwittingly the algorithm or the data set could perpetuate that type of discrimination and bias. The data could potentially be unreliable, it could be inaccurate or incomplete. Another risk is that the data could have the unintended effect of using protected information. So if the data is gathering from information about the person's activities, or their likes and dislikes. It could, for instance, find out that the person is active or supports different medical initiatives, and that could be correlated to the fact that the person has a certain medical condition. And that information could be protected information under the Federal Genetic Non-Disclosure Information Act. That's just an example of how the use of big data could potentially lead to the unintended disclosure of protected information. There are obviously major rewards as well with the use of big data. As Jeanette talked about, there's a possibility that using big data and using algorithms could actually eliminate discrimination and bias. One example would be that data could potentially expand an employer's traditional applicant pool, and instead of relying on referrals or word of mouth, which tends to solicit recruits from within a person's own affinity group, it could expand the potential group of applicants and allow for recruiting in more diverse groups. It also, as we talked about earlier, can create a more productive workforce by identifying better applicants that have higher retention rates. This is a developing area that the Equal Employment Opportunity Commission is watching. And I do believe that we are going to see more litigation related to big data and the use of artificial intelligence in employment. The EEOC held a panel on the topic of big data and its use by employers in October of 2016. Interestingly, this panel was organized by then EEOC Commissioner Victoria Lipnick, who was following that was named the acting chair of the EEOC by President Trump. So as the now acting chair, we could expect that there's potentially will be continued interest in this area. And the EEOC has itself signaled that it noted that data-driven selection devices are one of its areas of particular concern in its 4-year strategic enforcement plan. That's a plan that lays out areas where the EEOC is paying particular attention to different topics and sets forth the EEOC's enforcement goals. There has not been a large lawsuit related to the use of artificial intelligence, specifically in the area of recruiting. But legal commentators believe that there may be a basis for potential lawsuits under a number of different federal statutes, which are identified here. And I'll speak a little bit about what most legal commentators believe could be a potential litigation point is under a disparate impact theory, which essentially the type of lawsuit that would be brought is by a group of people that have a protected class underneath one of these lawsuits. For instance, a person of color, based on sex, based on disability, who allege that they have been excluded or otherwise discriminated against because of a employment practice that is not intentionally discriminatory. So there may not be any intentional discrimination, but rather there's a neutral employment practice that has the effect of creating discrimination. So for instance, one of the examples that the EEOC considered in their October 2016 panel was the use of, in an algorithm, the use of someone's zip code. That an employer, for instance, may select to include only applicants within a certain radius of their employment site and not include other zip codes that are potentially further away. That could have the unintended consequence of perhaps excluding certain neighborhoods and excluding, for instance, people of color if they live in that neighborhood, or whatever affinity group may be present in that particular area. So it's an example of a neutral decision that obviously has no discriminatory intent, creating a potentially discriminatory impact by not even allowing a certain group in the door to be considered as an applicant. Another example would be that legal commentators have talked about is the algorithm may create a, it may, for instance, say, you know, that this certain candidate has a projected rate of absenteeism, and it could exclude the candidate because they're likely to be absent from work. But if the reason for those absences has something to do with a medical condition or a disability, the employer could unwittingly exclude that person based on the fact that they may be disabled or have a medical reason for not being able to be present at work. This type of discrimination is being referred to as digital discrimination, and it is a very much developing area of the law. Some legal commentators believe that the way that our current statutes are written don't even necessarily anticipate the ability, or don't anticipate the digital revolution that we're now in. And so I think we will see the law really being reformed by these different lawsuits as they start to come up. So there are some best practices that we're advising our clients to put into place if they are using big data. Jeanette talked a little bit about the importance of allowing the computer to do the work. I'm going to push back a little bit on that and say that we do really recommend that employers ensure that there's responsible oversight when they're using big data. So that means that recruiters and managers do need to be well trained in non-discrimination principles, and they need to be reviewing what's actually happening with the data set and the outcomes that are occurring. And if there are disparate impacts or adverse impacts on particular groups, an employer needs to be proactively addressing those. Employers also need to put in safeguards to prevent discrimination. We talked a little bit about making sure that the algorithm or the data set is actually evaluating someone's ability to do the job and not just their demographic characteristics. So the algorithm should be measuring someone's knowledge, skills, and abilities that are specifically related to the job at issue and not their demographic characteristics. Employers should always audit the results of any big data that they're using, and they should retain the data as well. So by auditing, an employer needs to make sure that the data set that they're using is actually representative, that it's inclusive, and that it's accurate. I'll turn now to discuss a few other topics that are not related to big data, but that have to do with data that an employer may solicit during the recruitment process. Specifically, I'll talk a little bit about criminal background information and wage history information, which are two areas of the law that have been hot topics in recent years. So during the recruitment process, employers may ask candidates questions. Some of those questions may relate to their criminal background. Some employers may even require a background check prior to hiring someone. The EEOC has been very active in this area. They issued a guidance on employers' use of arrest and conviction records back in April of 2012. The concern here is that this type of information tends to exclude disproportionately people of color. Similarly, states have been very active in this area, and there have been numerous states that have adopted laws that are so-called ban-the-box laws that apply to private employers. These ban-the-box laws are given that name because they typically have the effect of requiring private employers to eliminate from their employment applications the checkbox that a person was previously asked to check if they had either previously been arrested or had a conviction. Generally, the ban-the-box laws that have been passed in different locations, and I'll show you where they have been. These are just ban-the-box laws that apply to private employers. Many other localities have passed laws that apply to public employers. They take different forms. Some prohibit or limit the use of a person's arrest information, so just information about if someone has been arrested. Some impose time limits on the use of conviction information. So in the case where someone was arrested and then convicted of a crime, the ban-the-box law with a limitation on when an employer can consider that information. So for instance, here in Minnesota, the law requires that an employer cannot consider conviction information until after a conditional job offer has been made. Other ban-the-box laws also prohibit or limit the information given considering a job applicant's credit information. Obviously, this kind of patchwork of laws throughout the country creates a challenge for employers who are employing employees throughout our country. But there are best practices that employers should follow. The first step is determining, do we even really need to gather this information about someone's criminal background? How is it helping us? And if it is determined that we are wanting to do a background check, employers should make sure that they're complying with the EEOC's guidance, which requires that the criminal background check is really assessed in a very individualized way. So the employer needs to determine, what is the conviction for? When did the conviction occur? Does it have any relationship whatsoever to the person's ability to do this job? If there is a decision that a person's criminal background disqualifies them for the particular position, employers need to make sure that they're following the specific process that's mandated by the Fair Credit Reporting Act for communicating that decision to employers, or to applicants, excuse me. I'll turn now to discuss pay equity. This is another area that we've seen a growing focus on at both the federal and the state level. And specifically what's particularly important to focus on the recruiting process is new laws that have been banning employers from asking a candidate about their salary or wage history at any point during the hiring process. So that means that an employer cannot ask, what were you previously paid at your prior employer? The law was just passed in New York City. It's been passed in the other locations that are listed on the slide. We think that this is going to be expanding across the country. So employers need to take note and consider, is this something we should be asking candidates about on our job applications? And if we are doing it, how do we make sure that there's no pay inequity that's created? Because the whole purpose of these laws is the belief that basing a candidate's pay or their negotiation of their pay on their prior pay tends to perpetuate pay inequity and particularly wage gaps between women and men. Lastly, I'll talk a little bit about website accessibility. This is a area of increased litigation that we've seen under the Americans with Disabilities Act. Disabled individuals have brought lawsuits against employers and other companies alleging that their websites are not accessible to individuals with disabilities. We've seen a particular rise in these types of lawsuits related in the financial services industry, but it applies in the recruiting context as well. If you're using a website or a mobile app or social media to recruit candidates, you need to make sure that your platforms are accessible to individuals with disabilities. There have not been any specific guidelines that have been issued by the Department of Justice, although they've been anticipated for a number of years at this point. I'm not sure if we'll see them anytime soon. However, where lawsuits have occurred, the Department of Justice has indicated that compliance with the guidelines that have been issued by a private consortium, the Web Content Accessibility Guidelines noted here, do meet the requirements of Title III of the Americans with Disabilities Act. With that, I'll thank you for your attendance here today, and I'm certainly eager to answer any questions that you may have, and also excited to open up the cocktail hour as well.
So, Jenny, in terms of this, oversight, is it better to, have the detailed information, or to be at, kind of a higher level, if you're, of what goes on in the algorithm? I mean, how much do you really want to dig into the detail of that. And, I'm sure it's a daunting task for a lot of people to, go into that level of detail, but would you advise that they actually do it, or that they stay a little bit above that? Or what do you, what
I think it's a very challenging issue for employers to sort out, because employers want to recruit diverse candidates, and the only way to recruit diverse candidates is to know about their diversity. And many employers, rightly so, feel very hamstrung by their inability to ask specific questions to gauge diversity. Especially when they may be federal contractors, they may have specific affirmative requirements to have a diverse workforce. But at the same time, employers are also very wary of stepping into a potential lawsuit by asking someone about their sexual orientation, or asking someone about, do you have kids? What is your marital status? Those are protected statuses in some states, including in Minnesota, where familial status and sexual orientation are protected characteristics. So I think employers really have feel like it's hard to sort out. Do we ask the personalized information or not? Generally, as an advisor, I advise employers not to ask specific questions about someone's protected status or their demographic characteristics during the recruiting process. If a candidate voluntarily discloses that information, that's fine, but soliciting that information can be risky in a non-discrimination lawsuit.
But how about in the context of big data, and the analysis of big data? You really do you advise employers to really engage with folks like WCN to get into the weeds and understand how it all works, or to let them do that and have that be their business? And it's got to be a bit of a dilemma for the employer. How much do they get into that detail?
Right, and that's a great question. It is a dilemma, and for some employers, it's great. They simply do not have the capacity to assess that in an intelligent and comprehensive way. I think employers do need to ask questions. They need to find out, okay, where is the data being pulled from? How do we ensure that it's accurate? How do we ensure that it's free from bias, from biases? How do we make sure that it's not incomplete? So employers do need to ask those difficult questions. I know some employers even ask for indemnification provisions. But certainly employers do need to know what are we relying on.
So they can't just say, ignore it, stick their head in the sand and say, we didn't know any of this. That's not good enough.
No, I think that no court is going to buy that as a defense to a potential lawsuit.
So question just related to that, if the tools are used, whether it's big data or other online assessment tests or things like that, as a recommendation versus like, okay, if it's like going like this says, this is top candidate and I will automatically hire them. If there's that, like it's just an extra input into your process, does that change and then assuming then is, you're not making biased decisions, right? Implicit or not, or like how does that change? Does that change versus just relying on this algorithm or this online personality test said this? I'm just hiring the top 10%, and forget about the rest. Like, does that change sort of from a legal standpoint?
Well, I think that in any decision, there's going to be some kind of discretion. The employer is exercising discretion in order to determine who is hired. I think where the potential legal problem comes in is if in a potential lawsuit, a court is going to look at, okay, well, what was the pool? Were you looking at a pool of candidates that was in fact diverse, or that was not diverse? And if you're as you said before, if there's garbage in is kind of garbage out. You want to make sure that you're not even if you're exercising discretion, that the discretion is being exercised in a way where you're not potentially running afoul of a non-discrimination law.
What are your thoughts on employers either preferring or sometimes even requiring that students come from certain schools or are from certain majors? If the employers don't really have any data to show that those schools or majors actually result in more productive employees. We've had some discussions at College Recruiter with a couple of our clients recently that have basically become school agnostic, because when they look back at people who have been with them for 3, 4, 5 years, they find that there's actually no correlation at all between what school they went to, who's still with them, who's productive. And Ernst & Young in the UK even found an inverse relationship between the quality of the school and the quality of the employee. So, for those of us who went to decent schools, clearly that's a flawed methodology. I'm looking at you, Steve. But what are your thoughts, Jenny, on that? Because it's widely accepted in the college recruiting space that you have your primary school, your core schools, your secondary schools, certain majors, and it's just sort of accepted that that's where the best candidates come from.
Right. I think that this, there's not necessarily a legal issue with recruiting from a specific school versus another one, although I think that we talked, it does create kind of an interesting question about, are those schools proxies for discrimination, because only certain students are able to get into the very elite schools, and are we somehow excluding other candidates from other groups because they're not able to either to pay, frankly, for those very expensive educations. So I think this is really something where employers just need to look at their own internal data set and see what their experience is, and know that it's hard for many of us to not go with the kind of the fancy brand name. But this is a situation where if you have had a great experience with candidates from schools that aren't in the Ivy League, it just doesn't make sense from a business perspective to target solely those institutions. Great. Well, I want to thank everyone for coming, and looking forward to getting the chance to speak to some of you. And we'll certainly continue the conversation online, and we have our hashtag if you want to post anything on Twitter as well. Thanks.